Marcus Webb had been guest services supervisor aboard Carnival's Liberty of the Seas for 6 years, when he made a decision that would destroy his career, cost Carnival Cruise Lines $19.3 million, and expose a pattern of systematic discrimination that executives had worked for years to bury. He was 34 years old, experienced enough to understand maritime hospitality protocols, but apparently convinced that his assessment of which passengers belonged in premium accommodations was more reliable than their paid reservations. One Saturday afternoon in Port Canaveral, Florida, he received word from the revenue management team about cabin reassignments for an overbooked sailing. Standard protocol dictated random selection based on booking class and loyalty tier. But Webb had his own protocol. Families who didn't look like they could afford premium cabins probably couldn't. And this particular family, a black family of 4 with 3 children checking in for a week-long Caribbean cruise, didn't fit Webb's mental image of premium suite passengers. What Webb did next? Overriding a confirmed reservation, fabricating a system error, and relocating a family from an $8,400 ocean view balcony suite to a $2,100 interior cabin without compensation would become textbook evidence of how corporate discrimination operates when middle management believes company profits matter more than passenger rights. He'd done it before, 17 times in 4 years, according to internal records. All 17 incidents involved families of color. All 17 were coded as system errors or voluntary downgrades. And this time, he'd targeted someone who'd spent 12 years litigating exactly these cases on behalf of passengers against cruise lines. A black man in his mid-40s, Dr. Marcus Jennings, stood at the guest services desk with his wife Alicia and their 3 children, ages 6, 9, and 12, clustered around their luggage. His printed boarding pass clearly showed Suite 8247, Deck 8, Premium Vista category. His credit card receipt confirmed payment in full 8 months prior, $8,437.50. No violation, no overbooking notification, no prior contact, just a family arriving for their anniversary vacation. But Marcus Webb saw them and decided they belonged somewhere else. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these expose patterns corporations spend millions trying to hide, and your support helps us demand accountability from companies that think settlements are just business expenses. Carnival's Liberty of the Seas sits permanently docked at Port Canaveral's Terminal 3, a massive 15-deck vessel capable of carrying 3,634 passengers and 1,160 crew members on week-long Caribbean itineraries. It's the kind of ship that processes thousands of embarkations every Saturday. Families dragging oversized suitcases, couples carrying duty-free alcohol, first-time cruisers clutching folders of printed documents, loyalty members breezing through priority boarding. The main terminal building is all white tile and blue carpet, with Carnival's distinctive red and blue funnel logo plastered across every surface. The guest services desk sits just inside the ship's atrium on Deck 3, a curved marble counter staffed by 4 representatives in matching polo shirts, processing check-ins, answering questions, resolving booking issues. Behind them, a massive LED screen displays the ship's itinerary: Cozumel, Grand Cayman, Jamaica, back to Port Canaveral. 7 days, 6 nights, paradise guaranteed. It was 2:45 p.m. on a Saturday in July, the kind of oppressive Florida heat that makes the air-conditioned ship feel like salvation. The boarding process was in full swing. Families streamed through security, handed their passports to officials, received their plastic SeaPass cards that function as room keys, payment cards, and identification. The atrium buzzed with activity, passengers taking selfies with the massive chandelier, kids running toward the buffet, couples studying deck maps trying to locate their cabins. Premium Vista Suites are located on Deck 8, port and starboard sides, with private balconies offering ocean views. These suites run $6,500 to $9,800 for week-long sailings depending on the season, featuring separate living areas, premium bedding, priority embarkation and debarkation, exclusive access to the Serenity adult-only retreat area, and complimentary room service. The clientele who book these cabins tend to be repeat cruisers, anniversary celebrants, families splurging on special occasions, They expect what they paid for. Deck 3, interior cabins are a different story. No windows, no natural light. Located directly above the engine room, they vibrate slightly when the ship is at sea. They're the cheapest cabins on the vessel, marketed to budget-conscious travelers and crew members' families. The difference in price reflects the difference in experience. $2,100 versus $8,400. Nobody books a Premium Vista Suite and expects to end up in an interior cabin unless something has gone catastrophically wrong. Dr. Marcus Jennings had been a partner at Salinger and Whitmore Maritime Law for 12 years. 12 years representing passengers in admiralty disputes against cruise corporations. He'd spent 8 years before that as an associate, handling insurance claims, personal injury litigation, and contractual disputes in maritime commerce. He'd built his reputation on 3 specialties: cruise line liability for passenger injuries, violation of maritime safety regulations, and systematic discrimination in passenger accommodations. He'd litigated 47 cases against major cruise corporations: Royal Caribbean, Carnival, Norwegian, Celebrity, Princess. He'd won or settled 44 of them, securing over $180 million in combined awards and settlements. His colleagues called him relentless. His opponents called him the passenger's lawyer who knows more maritime law than in-house counsel. He testified before congressional subcommittees on cruise industry regulation, published articles in Maritime Law Journal, and taught seminars on admiralty jurisdiction at University of Miami School of Law. When cruise passengers discovered their rights had been violated, denied medical care, injured by negligent crew, discriminated against in accommodation, they hired Marcus Jennings. Jennings had graduated from Howard University with honors before earning his JD from University of Virginia School of Law, where he'd clerked for a federal judge in the Eastern District of Louisiana, handling admiralty cases. He'd passed the bar in Florida, Louisiana, and New York, jurisdictions where most cruise litigation is filed due to forum selection clauses in cruise contracts. He'd earned board certification in admiralty and maritime law from the Florida Bar, a specialty designation fewer than 200 attorneys in the state hold. The American Association for Justice had recognized him with the Wiedemann and Wysocki Award for Maritime Passenger Advocacy. At 44 years old, Marcus Jennings was exactly where he'd worked to be: financially secure, professionally respected, and finally able to take his family on the kind of vacation he'd spent years suing cruise lines over. His wife, Alicia, was a pediatric nurse at Jackson Memorial Hospital. Their 3 children, Kamari, 12, Nia, 9, and Elijah, 6, had never been on a cruise before. This trip was celebrating Marcus and Alicia's 15th wedding anniversary, a milestone they'd planned for over a year. Marcus wasn't the kind of attorney who went looking for lawsuits. He represented clients who'd already been harmed. He settled cases whenever possible. He preferred negotiation to litigation, but he also knew exactly what to document when corporations violated their own policies. And he'd spent enough time reading internal cruise line memos obtained through discovery to recognize patterns of discrimination when he saw them. That Saturday, the Jennings family had arrived at Port Canaveral at 1:30 p.m., well within their assigned boarding window. They'd checked 3 suitcases and 2 carry-ons at the terminal, received their SeaPass cards, and headed up the gangway with their printed confirmation showing Suite 8247. Marcus had booked the Premium Vista Suite specifically because it slept 5 comfortably, included 2 bathrooms, and offered enough space that his kids wouldn't be climbing the walls by day 3. He'd paid in full using his American Express, received email confirmation, selected his dining time and shore excursions, and completed online check-in 48 hours prior. He wore khaki shorts, a Tommy Bahama shirt, and boat shoes. Alicia wore a sundress and sandals. The kids wore matching Carnival t-shirts Alicia had ordered for the trip. They looked like what they were, a family excited about their vacation. They'd saved for this. They'd planned for this. They'd followed every instruction in Carnival's pre-cruise documentation. Marcus had been on cruises before, mostly for maritime law conferences that chartered ships for continuing education seminars. He knew ship layouts, passenger rights, and the difference between legitimate operational issues and policy violations. His laptop bag contained a tablet loaded with his case files. He'd planned to review depositions during the sea days, and copies of maritime statutes, cruise line regulations, and passenger rights documentation. Not because he expected to need them, but because lawyers travel with their work. The family had stopped briefly at the buffet after boarding, letting the kids grab pizza while Marcus and Alicia reviewed the deck map. Then they'd headed to guest services to ask about upgrade options. Marcus had read that sometimes suites on higher decks opened up, and he was curious about pricing. They'd planned to ask, not demand. A friendly inquiry from someone who knew these negotiations happened frequently, but when they gave their cabin number to the guest services representative, something shifted in Marcus Webb's expression. His smile became fixed. His eyes narrowed slightly. He turned to his computer, typed rapidly, and then delivered the news that would change everything. There'd been a mistake. The suite was no longer available. The family had been moved to Deck 3. And when Marcus Jennings asked why, when he showed his confirmation, when he politely requested an explanation, Webb decided that this black passenger who clearly didn't understand his place, needed to be reminded that guest services supervisors don't explain company decisions to people who should be grateful they're on the ship at all. Marcus Webb was 34 years old. He'd been guest services supervisor aboard Liberty of the Seas for 6 years, promoted from guest services representative after 3 years of enthusiastic performance reviews. He was efficient, organized, and deeply concerned about maintaining what he called revenue optimization. His supervisors described him as results-oriented, but sometimes overly aggressive in maximizing cabin yields. Translation: Webb frequently reassigned passengers from premium cabins to lower-tier accommodations, citing overbooking or system errors, then resold the premium cabins at higher last-minute rates. In 6 years, Webb had compiled an internal record that corporate HR had flagged but never seriously investigated. 34 passenger complaints. 34? 22 of them specifically mentioned discriminatory behavior toward passengers of color. 14 had been escalated to Carnival's corporate office. 7 resulted in settlement agreements with confidentiality clauses. 0 resulted in Webb's termination or meaningful discipline. Webb had a pattern. He targeted families who appeared, in his assessment, unlikely to escalate complaints beyond shipboard resolution. Families traveling with young children, first-time cruisers, passengers who seemed financially stretched, and especially passengers of color who'd booked premium accommodations. In 2019, a black couple celebrating their honeymoon was relocated from a suite to an interior cabin because Webb claimed their credit card had been declined. The card was valid. The charge had cleared weeks prior. Corporate settled for $45,000. In 2020, a Hispanic family of 6 was told their adjoining Premium Vista Suites had been accidentally double-booked, and they'd be more comfortable in 2 separate interior cabins on different decks. The suites were never double-booked. Corporate settled for $68,000. In 2021, an Indian-American family was informed that their suite had a plumbing issue, and they'd need to temporarily relocate to a lower deck cabin for 1 night. The plumbing worked fine. The suite was resold to a white couple at a premium rate for New Year's Eve. Corporate settled for $112,000. The pattern was documented. Internal emails showed revenue management thanking Webb for creative cabin management that generated tens of thousands in additional revenue per sailing. HR had received complaints but treated each incident in isolation, never connecting them to a systematic practice. Webb remained on duty, receiving performance bonuses, promoted to lead supervisor training sessions on revenue optimization. That Saturday at 2:38 p.m., Webb received an alert from revenue management. Suite 8247 could be resold to a walk-up booking for $2,500 if the current occupants could be relocated. Standard protocol required contacting passengers 72 hours prior to offer compensation and alternative accommodations. But the Jennings family was already on board. In Webb's mind, this was simple math. The family had paid $8,437. A couple had just offered $12,500 for the same suite. That was $4,063 in additional revenue. All he needed to do was relocate the current occupants, cite a system error, offer a small onboard credit as compensation, and process the upgrade. He'd done it 17 times before. It always worked. He didn't consider that the Jennings family might refuse. He didn't think about verifying whether they had legal knowledge. He didn't check if they'd understand their passenger rights. He just saw a black family with 3 kids and assumed they'd accept whatever he offered, grateful to be vacationing at all. When the Jennings family approached guest services at 2:42 p.m., Webb had already made his decision. He'd flagged their reservation in the system, notified bellhops to redirect their luggage to Deck 3, Cabin 3187, and prepared his script: system error, no availability, lower cabin assigned, complimentary $200 onboard credit as compensation. His mind immediately filled in a narrative. This family probably booked the suite on a payment plan. They probably scraped together the deposit. They probably couldn't afford the incidentals anyway. Premium suites generated expectations for specialty dining, shore excursions, spa services, beverage packages. Moving them to a lower deck was doing them a favor, preventing embarrassment when they couldn't afford the lifestyle the suite suggested. He scanned the family: Marcus in casual resort wear, Alicia in a sundress, 3 kids in matching t-shirts. In Webb's mind, they didn't look like premium suite passengers. They looked like people who'd won a contest or used a discount code. People who wouldn't understand that reassignments happen, that guest services has discretion, that complaining wouldn't change the outcome. He approached them with practiced sympathy, ready to deliver news he'd delivered many times before, to passengers he'd already decided wouldn't fight back. Do you think cruise lines should face federal investigation after 3 or more documented incidents of discriminatory cabin reassignments? Drop your answer below. Marcus Jennings was studying the deck map, trying to orient himself to the ship's layout, when he became aware of the guest services supervisor approaching their position. He looked up and saw a white man in his mid-30s wearing a name tag that read Marcus Webb, Guest Services Supervisor, walking with the kind of purposeful stride that suggested he wasn't coming to deliver good news. "I'm sorry, but there's been a mistake with your cabin assignment." Marcus blinked, confused. "What kind of mistake?" "We booked Premium Vista Suite 8247. Webb's smile was practiced, sympathetic, and completely insincere. "That suite is no longer available. We've moved you to Deck 3. "Deck 3? Marcus felt Alicia stiffen beside him. "That's interior cabins, near the engine room. We paid for an ocean view balcony suite. The system shows a reassignment. It happens sometimes with last-minute bookings." Marcus pulled his phone from his pocket and opened his email. "This wasn't last minute. We booked 8 months ago. Here's my confirmation email." He turned the screen toward Webb, showing the Carnival confirmation dated November 2022 for July 2023 sailing. Suite 8247, Premium Vista category, payment confirmed. Webb glanced at the email briefly, his expression unchanging. "Sir, I understand your frustration, but the decision has been made. Your luggage is already being moved." Marcus felt his professional instincts activate. He'd seen this script before in depositions, in internal cruise line emails, in settlement negotiations. He knew exactly what was happening. "Mr. Webb, can you show me in your system what caused this reassignment?" "It's a computer error. These things happen." Marcus's voice remained calm, but his wife recognized the shift in his tone. "What specific error? Overbooking? Mechanical issue? Safety concern?" Webb's jaw tightened slightly. "I don't have those details. The system flagged your cabin for reassignment." Marcus reached into his laptop bag and pulled out a folder containing printed documents: his original booking confirmation, payment receipt, Carnival's guest bill of rights, and a copy of the Cruise Vessel Security and Safety Act. He placed them on the counter methodically. This receipt shows payment in full on November 18th, 2022, 8 months ago. If there was an overbooking issue, Carnival's policy requires 72-hour notification and compensation equal to or greater than original booking value. I received no notification. Is this an overbooking situation? Webb's expression hardened. "Sir, I don't need a lecture on company policy. The cabin reassignment stands." Marcus's youngest son, Elijah, tugged on his father's shirt. "Daddy, are we still going on the cruise?" Marcus crouched down to his son's eye level. "Yes, buddy, we're going on the cruise. Daddy just needs to talk to this man about our room." He stood and pulled out his phone, opening a voice recording app. "I practice maritime law, specifically cruise line liability and passenger rights violations. This conversation is being recorded for potential litigation purposes. Under Admiralty jurisdiction and the Cruise Vessel Security and Safety Act, you're required to provide written documentation of any involuntary cabin reassignment. This is where corporate training becomes liability. Marcus Webb had been trained to maximize revenue. He'd been rewarded for creative cabin management. He'd been taught that passenger satisfaction was secondary to profit optimization. But he'd never been trained to recognize an attorney who specialized in exactly the violation he was committing. He'd never been warned that some passengers understand maritime law better than supervisors. He'd never been told that recording a conversation with a cruise line employee is perfectly legal and admissible in federal court. Webb was operating from a playbook that worked on passengers who didn't know their rights, who accepted corporate decisions as final, who believed guest services supervisors have absolute authority. But Marcus Jennings had spent 12 years deposing guest services supervisors, reading their training manuals, obtaining their internal communications, and exposing exactly this pattern of discriminatory reassignments designed to maximize revenue by targeting passengers who appeared unlikely to escalate. The guest services area had grown crowded. A line of passengers waiting for assistance had formed behind the Jennings family. Conversations quieted as people sensed tension. Several passengers pulled out phones. "Sir, company policy is company policy." Marcus's voice remained measured, but his words carried across the atrium. "Then you should know your company policy just violated the Cruise Vessel Security and Safety Act, which requires non-discriminatory treatment in passenger accommodations. You've reassigned a confirmed reservation without cause, without notification, and without compensation. That's a federal violation." A woman in line behind them whispered to her husband, "He's a lawyer." Another passenger started recording on his phone. Webb's face flushed. "Sir, you can either accept the new cabin assignment or we can arrange for you to disembark." Marcus pulled out another document. "This is Carnival's Contract of Carriage. Section 4, Paragraph C. Quote, the carrier reserves the right to reassign cabins due to mechanical failure, overbooking, or safety concerns, provided reasonable alternative accommodations are offered and passengers are notified prior to embarkation. Have you offered alternative accommodations of equal or greater value? I've offered cabin 3187. That's an interior cabin worth $2,100. My confirmed reservation was for a suite worth $8,137. That's not equal value. That's a $6,300 downgrade. Is Carnival offering compensation for that difference? We're offering a $200 onboard credit." A passenger in line gasped audibly. Marcus continued, $200 credit against a $6,300 difference? And you're claiming this is due to what? Mechanical failure, overbooking, or safety concern? Webb said nothing. "Because if it's none of those," Marcus said, his voice carrying perfect professional authority, "then this is a discretionary reassignment. And discretionary reassignments that disproportionately target families of color are discrimination. I've litigated this exact scenario against Carnival twice. Once in 2018, settlement for $112,000. Once in 2021, settlement for $89,000. Both involved guest services supervisors making discretionary downgrades of black families from premium cabins." Webb's hand moved toward his radio, ready to call security. "Get your supervisor. Now. I am the supervisor. Then get your manager, the hotel director, the staff captain, someone with authority to reverse this decision before I add your name as a defendant when I file suit in Miami federal court on Monday morning." Webb hesitated. He'd never had a passenger respond like this. He'd never had someone cite specific case law, specific settlements, specific violations. He'd certainly never had a maritime attorney recording every word for potential litigation. Alicia spoke for the first time, her voice quiet but clear. "We just wanted to take our kids on a cruise for our anniversary. We saved for this. We planned for this. We did everything right." A passenger in the growing crowd called out, "Let them keep their room. They paid for it." Another voice, "This is messed up." Webb's radio crackled. "Guest services supervisor. Webb, please respond." He pressed the button. "Webb here. I need the hotel director to guest services. Should passengers be required to prove they belong in premium accommodations when cruise staff question their bookings? Let me know what you think." Hotel director Sarah Chen arrived at guest services within 4 minutes. She was a 19-year veteran of Carnival's operations, having worked her way up from guest services representative to hotel director overseeing all passenger accommodations and services aboard Liberty of the Seas. She'd seen crew mistakes, passenger disputes, and occasional misunderstandings, but rarely situations that required her personal intervention in the atrium in front of dozens of witnesses. She approached quickly, assessing the scene. A family of 5 surrounded by luggage, a crowd of passengers watching and recording, and Marcus Webb looking like a man who just realized he'd made a catastrophic error. "Mr. Webb, what's happening here?" Webb's voice was defensive, tight. Family booked Suite 8247. Revenue management flagged it for reassignment. New booking came in at premium rate. Standard cabin optimization. Chen's expression didn't change, but her eyes went cold. "Did you notify the family prior to embarkation? They were already on board when the flag came through. Did you offer compensation equal to the value difference?" "I offered $200 onboard credit." Chen turned to Marcus. "Sir, I apologize for this disruption. May I see your confirmation?" Marcus handed her his phone, showing the email confirmation, his printed receipt, and his payment documentation. Chen examined each carefully, noting the booking date, payment date, cabin category, and confirmation number. She pulled out her tablet and accessed the ship's booking system. Her fingers moved rapidly across the screen, pulling up the Jennings reservation, the timeline, the payment history, the reassignment flag. "Mr. Jennings, your reservation was confirmed November 18th, 2022. Payment cleared same day. No overbooking situation exists. No mechanical issues reported in Suite 8247. No safety concerns documented." She turned to Webb. "Where did the reassignment request originate?" "Revenue management. New booking offered $12,500 for the same suite." Chen's voice dropped. "Did you verify whether the existing passengers were willing to accept a voluntary downgrade?" "They're on board." "I assumed—" "You assumed," Chen cut him off. "You assumed these passengers would accept a $6,300 downgrade for $200 compensation without being asked." Chen turned back to Marcus. "Mr. Jennings, on behalf of Carnival Cruise Lines, I sincerely apologize. This reassignment should never have been processed. Suite 8247 remains your confirmed accommodation. Your luggage will be immediately rerouted." Marcus nodded. "I appreciate that, Director Chen. But you should know I practice maritime law. I specialize in cruise line liability and passenger rights litigation." Chen's face went pale. "I understand. This isn't the first time I've encountered discriminatory cabin reassignments. I've litigated similar cases against Carnival specifically. I'll need to report this to corporate immediately." Marcus continued. "What I'd like from you right now is written confirmation that Suite 8247 remains our confirmed accommodation. Documentation of this incident, including Mr. Webb's explanation for the reassignment, and a copy of all communication between guest services and revenue management regarding our reservation. You're entitled to all of that. I'll have it prepared within the hour." Chen turned to Webb, her voice professional but final. "Mr. Webb, please see me in my office as soon as we complete reaccommodation procedures for the Jennings family." Webb's hands trembled slightly as he typed into his computer, reversing the reassignment and flagging the suite as confirmed. "Your suite is now locked in the system, Mr. Jennings. No further changes can be processed without your written authorization." "Thank you, Director Chen." Chen handed Marcus her business card. "My direct line. If you experience any issues during this sailing, any at all, contact me immediately." A passenger in the crowd started clapping. Others joined. Within seconds, the atrium filled with applause. Should cruise line employees face immediate termination for discriminatory cabin reassignments, even if revenue motivated? Drop your answer. Within 3 hours, videos of the confrontation had exploded across social media. Multiple passengers had recorded the entire exchange. Marcus presenting his documentation, Webb's refusal to provide explanation, the crowd reactions, Chen's intervention, and the final resolution. Black family downgraded on Carnival cruise until dad reveals he's maritime lawyer. Cruise line tries to move attorney from suite. He paid for, backfires. spectacularly guest services. Supervisor learns passenger. He discriminated against specializes in suing cruise lines. The outrage was immediate and overwhelming. The NAACP issued a statement demanding investigation into Carnival's cabin assignment practices. The National Association of Consumer Advocates called for federal oversight of cruise industry accommodation policies. Maritime law professors shared the videos in classes as examples of corporate discrimination and passenger rights violations. Marcus Webb's career aboard Liberty of the Seas ended within 72 hours. Before the ship even completed its 7-day itinerary, Carnival's corporate headquarters had reviewed the incident, the videos, Webb's personnel file, and his history of passenger complaints. Webb was removed from supervisory duties on day 2 of the sailing, reassigned to administrative tasks in crew areas where he had no passenger contact. On day 4, he received formal notification that his employment would be terminated upon the ship's return to Port Canaveral, and he was offered the option to disembark early at Grand Cayman. He disembarked. His termination was effective July 15, 2023. The termination letter was comprehensive and damning. Mr. Webb engaged in discriminatory passenger accommodation reassignment practices that violated company policy, federal maritime law, and passenger rights protections. Despite multiple complaints over 6 years regarding similar conduct, Mr. Webb continued to process cabin downgrades targeting families of color without authorization, notification, or adequate compensation. His actions on July 8, 2023, were not isolated incidents, but part of a documented pattern that exposed Carnival Corporation to significant legal liability. Marcus Jennings contacted his law partners while still aboard the ship. By the time Liberty of the Seas docked back in Port Canaveral, 7 days later, Salinger and Whitmore Maritime Law had prepared a comprehensive federal lawsuit. The complaint was filed in the United States District Court for the Southern District of Florida on July 22, 2023. Named defendants included Carnival Corporation, Marcus Webb individually, Liberty of the Seas Management, and revenue management personnel who authorized the reassignment. The claims were extensive and devastating. Violation of the Cruise Vessel Security and Safety Act prohibiting discrimination in passenger accommodations. Breach of contract for failure to provide confirmed reserved accommodations. Violation of the Civil Rights Act of 1964. Prohibiting discrimination in public accommodations. Violation of Florida's Civil Rights Act. Intentional infliction of emotional distress upon the Jennings family and their children. Negligent supervision and retention of employee, with documented pattern of discriminatory conduct. Fraud and misrepresentation in Webb's claim of system errors. Punitive damages for willful and malicious conduct. The complaint included evidence Jennings had obtained through years of prior litigation. Webb's complete personnel file showing 34 complaints over 6 years. Internal emails from revenue management praising Webb's cabin optimization, generating $400,000 plus in additional revenue annually. 22 complaints specifically alleging discriminatory treatment of passengers of color, 7 prior settlement agreements with confidentiality clauses, and testimony from former Carnival employees describing revenue optimization policies that incentivize supervisors to target passengers of color for downgrades. Carnival's legal team reviewed the evidence for 6 weeks. They reached the inevitable conclusion: indefensible. Multiple videos from passengers showed the entire confrontation. Jennings had recorded Webb's statements about revenue optimization. Chen's intervention was documented. Webb's personnel file was damning. The pattern was undeniable. Carnival settled in October 2023. The settlement agreement required $19.3 million payment to the Jennings family, immediate termination of all revenue management practices incentivizing cabin downgrades, implementation of federal civil rights training for all guest services personnel, creation of independent passenger advocacy office to review accommodation complaints, quarterly audits of cabin reassignments to identify discriminatory patterns, public apology from Carnival's CEO acknowledging systematic failures. The settlement was not confidential. The terms were filed publicly. The reforms were mandatory. The case sent shockwaves through the cruise industry. Royal Caribbean, Norwegian, and Princess Cruises all announced immediate reviews of their cabin assignment policies. The Cruise Lines International Association issued new guidelines prohibiting revenue-motivated downgrades of confirmed reservations. Marcus Webb's name became synonymous in maritime law circles with discriminatory accommodation practices. His termination was cited in Congressional Testimony about cruise industry regulation. His personnel file became Exhibit A in subsequent lawsuits against other cruise lines. Marcus Jennings testified before a congressional subcommittee on cruise industry oversight in November 2023. His testimony was powerful, detailed, and impossible to dismiss. I'm a partner at Salinger & Whitmore Maritime Law. I've practiced admiralty law for 20 years. I've represented passengers in 47 cases against cruise corporations. I've won or settled 44 of them. I know cruise line operations, passenger rights, and maritime law better than most corporate counsel. He paused, looking directly at the committee. My family and I booked a Premium Vista Suite aboard Carnival's Liberty of the Seas, 8 months in advance. We paid $8,137.50 in full. We received confirmation. We completed online check-in. We did everything passengers are supposed to do. We arrived excited for our vacation, our anniversary celebration, our children's first cruise. And the moment we walked up to guest services, I could see in Marcus Webb's eyes that he'd already decided we didn't belong in the cabin we'd paid for. He didn't ask if we'd be willing to downgrade. He didn't explain any legitimate operational issue. He simply announced that our suite had been reassigned, and our luggage was being moved to an interior cabin worth 1/4 of what we'd paid. Another pause. When I presented my confirmation, my receipt, my documentation, he dismissed it. When I cited maritime law and passenger rights, he told me company policy was company policy. When I identified myself as an attorney specializing in cruise line liability, he threatened to have us removed from the ship. This happens because cruise lines have created revenue optimization systems that incentivize employees to target passengers who appear unlikely to fight back. Marcus Webb had done this 17 times before, to other families of color. He'd been complained about 34 times. He'd cost Carnival over $400,000 in prior settlements. And he was still employed, still processing cabin reassignments, still rewarded with bonuses for generating additional revenue. His voice strengthened. $19.3 million is significant. It's accountability. It forces corporate policy changes. But it doesn't undo the humiliation my children experienced watching their father have to prove we deserved the cabin we'd paid for. It doesn't erase the message that even professional success, even legal knowledge, even perfect documentation isn't enough to protect black families from discrimination. He looked at each committee member. If this can happen to me, an attorney who's litigated these exact cases, who knows maritime law, who had resources to fight back, what happens to families who don't have legal knowledge, who don't know their rights, who accept what they're told because they don't realize they're being discriminated against? The room was completely silent. This isn't about one supervisor. This is about an industry that built profit models on the assumption that some passengers are less likely to complain, less likely to escalate, less likely to sue. And overwhelmingly, those passengers are people of color. Should federal law require cruise lines to report all cabin reassignments to a government oversight agency to identify discriminatory patterns? Drop your answer below. This wasn't just about a family being moved from one cabin to another. This was about a corporate system that financially rewarded employees for discriminatory practices and protected them through settlements with confidentiality clauses that hid patterns from public scrutiny. Marcus Webb's personnel file told the story Carnival executives had spent years burying. 34 complaints in 6 years. 22 involving allegations of discriminatory treatment toward passengers of color. 17 documented incidents of cabin downgrades targeting families who didn't match Webb's assessment of what premium suite passengers should look like. 7 settlements with confidentiality clauses totaling over $400,000, each one treated as an isolated incident. None of them connecting to the systemic practice Webb had perfected. The pattern was documented in internal emails obtained through discovery. Revenue management thanked Webb for creative cabin optimization. Supervisors praised his ability to generate additional revenue through reassignments. Performance reviews noted his results-oriented approach, and HR reviewed complaints but never connected them, never recognized the pattern, never asked why the same supervisor kept generating the same complaints about the same demographic targets. Marcus Webb's career is over. That's justice. He'll never work in cruise hospitality again. That's consequence. Carnival paid $19.3 million. That's accountability. They implemented mandatory civil rights training and independent oversight. That's reform. But money and policy changes don't undo trauma. They don't erase the moment Marcus Jennings' 6-year-old son asked if they were still going on the cruise, because a supervisor decided their family didn't deserve the cabin they'd paid for. The real question is, what changes now? Do cruise lines finally acknowledge that revenue optimization becomes discrimination when it disproportionately targets passengers of color? Do they finally recognize that confidential settlements hide patterns that congressional oversight should expose? Do they finally admit that training doesn't work when employees are financially rewarded for the exact behavior training says to avoid? Do corporations finally understand that some lawsuits aren't just business expenses, but proof of systematic failures that require cultural transformation, not just policy updates? Because if we don't fix the systems that kept Marcus Webb employed for 6 years, despite 34 complaints, if we don't address the profit models that incentivize discrimination as revenue generation, if we don't mandate public reporting of accommodation complaints so patterns can't be hidden, then we're just waiting for the next supervisor, the next family, the next viral video, the next multi-million-dollar settlement. Comment if you believe this should be federal law. Cruise lines that process 3 or more cabin downgrades found to be discriminatory within a 12-month period face mandatory Department of Transportation investigation and potential suspension of passenger boarding privileges. And if you think these stories matter, if you believe corporations need to be held accountable, not just with settlements, but with public exposure of systematic discrimination, if you think families deserve to vacation without proving they belong in accommodations they paid for, then hit that subscribe button. We're exposing the patterns these companies spend millions trying to hide. We're demanding reforms, transparency, and consequences that actually change behavior instead of just generating legal expenses. This isn't just about one cruise line, one supervisor, or one family. It's about the world we accept when we let profit optimization justify discrimination, when we treat civil rights violations as business expenses, and when we allow confidential settlements to hide patterns that public oversight should expose. Because passengers of color deserve to board ships with the same assumption of belonging that white passengers take for granted. And until that's true, we keep telling these stories.